We need to talk about this claim that the Biden administration was somehow persecuting Christians. Because this isn't just some stray political argument floating around out there. It is a coordinated talking point. It is the central theme of a 500-page report released by the Trump administration, and it's now being echoed across the entire ecosystem of editorials, commentary, and conservative media outlets, amplifying those claims and then amplifying each other. Hi, I'm Nate Charles, and welcome back to the Rule of Law Brief. Once you actually dig into this, once you read the report and look at how it's being presented, you start to see the problem pretty quickly. This argument only works if you fundamentally misunderstand how the Constitution handles religion. Before we get into the specifics, we need to do something that almost none of these pieces do. We need to talk about what the Constitution actually says about religion and how it's supposed to work. Now, you'll hear people, usually with about an inch-deep understanding of constitutional law, throw around the phrase, separation of church and state, as if that somehow settles the issue. But here's the thing. That phrase isn't actually in the Constitution. It comes from Thomas Jefferson in an 1802 letter where he described the First Amendment as building a wall of separation between church and state. But how does that relatively simplistic idea translate into constitutional terms? It doesn't mean that religion is excluded from public life, and it doesn't mean religious people are exempt from the law. The phrase separation of church and state actually refers to two separate but equal protections in the First Amendment. The first one is the Establishment Clause, which basically says that the government cannot adopt, endorse, or privilege a particular religion over any other religion. The second provision is the Free Exercise Clause, which basically says that the government cannot prohibit you from practicing your religion. That's the structure. And here's the key point. Those two principles don't always line up perfectly, and they never have. Think about it logically. If the government must remain neutral, not adopting any religious doctrine, then there will inevitably be situations where laws passed for secular reasons conflict with someone's religious beliefs. That tension isn't a flaw in our Constitution, it is built into the system. The Supreme Court has explicitly recognized this. It has described what it calls play in the joints between the Establishment Clause and the Free Exercise Clause, meaning there is a constitutional space where the government can accommodate religion, but it is not required to privilege it. So, how is the Supreme Court reconciled these occasionally contradictory provisions? Starting with a case called Employment Division v. Smith, the Supreme Court held that if a law is neutral and generally applicable, then the government can enforce it, even if it incidentally burdens religious practices. This is now black-letter law. It is well settled. In general, where a law applies to everyone equally, the Constitution does not require a religious exemption. You have to follow that law, even if it contradicts with a good faith religious belief. Because if you didn't, we wouldn't have a functioning legal system. We'd have a system where anyone could opt out of any law simply by invoking their religious beliefs. And that's where this rhetoric really falls apart. This line of reasoning is particularly pernicious when it is applied to COVID vaccine mandates and other public health measures and frames them as religious persecution. That's just not legally serious. Public health is one of the oldest and most fundamental functions of any government. The word quarantine is literally derived from the practice of segregating ships coming into the harbors of Venice during the Renaissance era for 40 days. Quarantine is literally derived from the word 40 in Italian. And in American law, we have clear precedents that apply this very concept. Jacobson v. Massachusetts. The Supreme Court upheld mandatory vaccination over individual liberty objections over a century ago. As a matter of necessity, when you're dealing with a public health crisis, the government has broad authority to act in the interests of general welfare. Now combine that with Smith. If a vaccine mandate is neutral, generally applicable, and designed to protect public health, then the fact that it happens to conflict with somebody's religious beliefs does not make it persecution. Now there may be a constitutional tension, but the law already tells us how to resolve it. And that's the part that the Trump administration and the Republican Party generally aren't saying out loud. Because once you strip away the rhetoric, the argument becomes pretty clear. It's not just asking for accommodation, it's asking for priority. It's arguing, implicitly, that when certain religious beliefs conflict with public policy, those beliefs should control. Not just to be respected, but to override facially neutral laws designed to promote the general welfare. And if you dig in closely to the anecdotal evidence being promoted in these reports, they're not just ordinary religious practices. They're edge cases. Often the most aggressive or absolutist interpretations of Christian doctrine. Yet they're being positioned as if they define the core elements of religious liberty. But again, the Constitution does not require the federal government or the state governments to adopt the most expansive version of any religious doctrine as public policy. That is not a request for religious liberty. That is a request for a religious veto, and that is not allowed under a constitutional system of government. And yet again, we have to go back to these two provisions of the Constitution, specifically the Establishment Clause. Because what the Republican Party essentially is asking for here is not the accommodation of a religious practice. It is asking for specific Christian doctrines to take precedence in public life. It is essentially asking for the federal government to establish Christianity as the fundamental religion of the United States. And that is a patent violation of the Establishment Clause. It is exactly what the Constitution forbids. In a country like the United States, we are always going to have tension between religious belief, public policy, and the rights of others. It is unavoidable. It is the natural consequence of the two provisions that make up this idea of the separation of church and state. It's inherent. But you don't resolve that tension by declaring persecution every time a neutral law applies equally to everyone. And we certainly don't resolve it by elevating one set of religious beliefs above another, because that is specifically prohibited. We resolve it through the legal test laid out in Smith. And perhaps even more importantly, if you attempt to redefine the word persecution to mean the government didn't adopt my religious beliefs, then the word means nothing at all.